Hey everyone, thank you for joining the webinar for estate planning for busy parents. Thank you so much for joining. I hope that this is going to be really informative for you. I'm Jeff Barinholtz. I'll go over a little bit more about me a couple of slides in, but I really think this is going to be informative and helpful for you. It's really the same information that you'd get in a one-on-one consultation, maybe even a little bit more. So you'll be well informed by the end of the presentation. And if you have any questions, though, you are welcome to reach out. You're welcome to schedule a follow-up call, anything that can help you in your guidance towards creating a comprehensive estate plan for your family. So I'm going to go ahead and share my screen, and we will get into it. So, like I said, my name is Jeff Barinholtz, and I think this is going to be a really great presentation for you guys that want to learn more about how to protect your kids and your assets in case something happens to you, and that would be if you're single, or if you're with a partner or married, and something happens to both of you. So, I'm really going to share with you some of the call them secrets of estate planning, and really more misconceptions that are out there. Now, I'm sorry for all the ums and the ands, but this is live. This is just me. I'm not fancy or edited. This is just a conversation, just like we would be having in a one-on-one consultation. My goal is, there was another my goal is for you to leave with a much better understanding of what can go wrong without estate planning, and what documents you need for a proper estate plan, how to get them in place, and get you educated so you can make an informed decision about what's best for you and for your family. Now, the best way to learn, I know this is tough, but is to really do as much as you can to pay attention, turn off your phone, get off of Facebook, Google. I mean, you really took the time to come here, so let's take the next 30 to 45 minutes to go through this, and give yourself that time, invest in yourself, and invest in your family. There will be a special bonus at the end that I'll mention, so please make sure to stick around towards the end so you can hear what that's all about. I really believe it'll be worth it. So please try to stay in there till the end. There is should be a link for a webinar workbook, either next to or somewhere around the video. I recommend that you print it out and you refer to it as we go through the webinar to make sure that you're engaged and really get the most out of the event. You can think about your questions, you can write them down in the workbook, and then you can, like I said, you can send them to me separately, and I will respond to those questions. So the planning that we do is not for ourselves, it's for our family members. So please keep this in mind, that you're doing this for your loved ones. So the first question is, do you have an estate plan? We realize it's not something that's fun to think about, and probably the latest statistics are 70% of Americans have no estate plan at all, no will, no trust, nothing, and probably you're part of that 70%, but hopefully by the end, hopefully you'll be on your path towards being part of the 30%. The three biggest doubts we get about estate planning, right, is there's a fear, right? There's a fear that somehow planning for death is going to hasten it in some way. And if you keep putting it off, maybe it'll never happen. This is a common objection. Of course, there's only two guarantees in life: death and taxes. So it's going to happen. It's best to be prepared for it. Um, Another objection is it's going to take too long, right? I don't have enough time, and I understand that. And we'll talk about that a little bit later. So you'll know exactly how long the process takes and what's involved, how much it costs. And then finally, you're thinking, well, I'm not old enough or wealthy enough. Maybe only someone who's in their 30s or 40s need this. And we'll go through and we'll sort of debunk that misconception as we go through the process. So I would say the good news is, right, I've never had a client sign their will or trust and then have something unexpected happen to them right afterwards. Yes, it does require some time, an investment of time and of money, but I think you'll find the benefits will far outweigh the costs, both financial and emotional. And you'll see as we go through the webinar, it doesn't really matter how much you have or how old you are. It's really, something in there to make sure that everyone's taken care of no matter what. Like I said before, estate planning, is not about you, right? It's about the people that you love the most. It's making sure that things are as easy and inexpensive as possible for your loved ones after you're gone, and that you can care for them whether they're 25 or 85, and whether you have $10 or $10 million in the bank, it doesn't matter. So one of the questions of the workbook is, who are you doing this for? Who are the people that you care most about? Write that down. It helps to really solidify things. So what you're going to learn today is posted up here on the slide. And again, it's the same information that you would get in having a one-on-one personal consultation. We do them over the Zoom or phone. So you're going to get the same information. Now, many parents that are on here probably have minor children, and you want to make sure that your kids are always going to be taken care of by the people that you love. So we're definitely going to talk about that. We're going to talk about probate court, what it is, why I think you should avoid it, and how you could avoid it. The differences of the different types of estate planning options that you have, and in terms of a will versus a trust. So we'll go over those differences, and how to best protect your children's inheritance from creditors, bankruptcy, lawsuits, and divorce. There is a way to get that done as well. So we will talk about how to start the estate planning process, what's involved, and how much it's going to cost. So everything is completely transparent. Everything will be out on the table. By the end of the webinar, you're going to have all the information you're going to need to make a decision about your own personal estate plan and how to move forward with my firm, just like you were sitting in a one-on-one consultation. And don't forget, there is that bonus at the end. So a little bit about me. Like I said, my name is Jeff Barinholtz. I've been practicing law for over 25 years now. I've done lots of different things, and regarding estate planning, I've been doing it for 10 or 11 or 12 years, I think. I'm the founder of Jeffrey S. Barinholtz LLC. We are a boutique estate planning law firm. That is primarily what we focus on now. The office is based in Beechwood, Ohio, which is a suburb of Cleveland, for those that may not be familiar, but we do serve clients across the entire state, and we do so on a remote basis, online, over the phone, Zoom, email. You will never have to leave your home to get your plan done. It can all be done from the comfort of your home and using the latest technology. My information is up here. You are welcome to contact me after the webinar. And like I said, happy to get any questions you have answered. So if you Google the law firm and the law firm name, you will see my information come up, or you want to search for an estate planning attorney near me, you can see the Google reviews that we have. This is an old slide. We're up to about 50 right now. And again, I've been practicing for a long time. We just never did Google reviews. It really wasn't a thing. But we realized how valuable they are and really started doing them last year. And I think we're close or above 50 by now. And you can go onto Google, you can go onto our website. They're duplicated on the website, and you can take a look at the reviews from real actual clients and get a better understanding of what their experience has been like working with our firm. So we said earlier that most people think that they don't have an estate plan, or they think that they don't because they haven't formally prepared a will or a trust. But the truth is you actually do have a plan. Even if you haven't formally prepared anything, it's just that the state of Ohio has a default plan, right? They've already written it for you. There are default rules that kick in when someone dies without having done any estate planning. You may not like the rules or like those default rules or those decisions that will be made, and you can override them by creating your own plan. So this way you can make these decisions yourself instead of through the state of Ohio. So let's talk about some of the goals of estate planning, right? You want to give what you have to whom you want, the way you want. You want to avoid probate court. You want to maximize how much is going to your loved ones. You want to be able to care for yourself during your lifetime, whether that be incapacity or issues with health and finances. Maybe you have some charitable intentions that you want to fulfill. You want to maybe have to minimize some taxes. You want to be able to care for other people, maybe kids and or even pets. You want to pass on your values and ideals, and you want to protect assets for your children from their creditors' bankruptcy, lawsuits, and divorce. These are all goals of estate planning. You might have one, you might have some, you might have all. Either way, they can be accomplished through a proper estate plan. Sorry, got a drink, otherwise I'm gonna lose my voice. So when you pass away without any kind of estate planning, it's called dying intestate. And this might be the situation you're in now. It's kind of a do nothing scenario. It means you'll end up with Ohio's default plan. And let's talk about what that is. So in Ohio, if you die without a will, your assets are going to be distributed according to state law. So they might go to people that you don't want them to go to. Your kids are going to get their inheritance once they turn 18, right? So if you have minor children and you're concerned that maybe they don't know how to manage funds responsibly, or perhaps they have a special needs or some other situation, that's a problem. They're just going to get that money outright when they turn 18, whenever the probate ends. Your spouse could remarry after you've passed and leave money to their new spouse and kids, right? There's no protection for that with the default Ohio plan. The judge might decide who's going to raise your minor children, who's in control of their money, and you're certainly going to be going through probate court and dealing with the time and expense that's involved with that, which we'll talk about in a minute. So for the parents on the webinar, if you have minor children, which means they're under the age of 18, one of your top priorities is going to be directing who would raise your children should something happen to you and your spouse or partner. And I think parents of minor children need planning really more than anyone, even those who are elderly, because there's nothing more important than deciding who's going to take care of your kids and that they're taken care of by the people that you choose in the way that you want, no matter what. So, like I said, if you don't have a plan, there's a default plan. You're probably not going to like it, and a judge is going to decide who takes care of your minor children. So this is one of the questions in the workbook. You know, who would you name as guardians for your children? Just start thinking about it. You don't have to have a final decision, but at least start, putting some words on paper. You don't really want to have a judge who's a complete stranger trying to figure this out after you're gone if you have not done proper planning. And this is kind of what that would look like. In a guardianship proceeding, a friend or a family member, if you've done no planning before and you're stuck on the default court process, they're going to have to petition the court for custody. If there's people who are fighting with each other and different people want to serve in that role, well, it's just going to take more time, cost more money, and the judge is going to have to sort of figure that out. It's rigorous, it's complicated, it's expensive, and it takes time. And that would be a very difficult situation for your children to have to go through and to sit through and figure out who's going to take care of them. And maybe it's somebody now, and the judge changes, and it's somebody else later. Why put your kids through that when you can avoid that with proper planning? Okay, there are situations where in-laws are going to battle each other, um, and it just takes time to sort all of that out. So some people say, look, yeah, there's a lot of people who would take care of it because we're fine. But this is the problem because, if you haven't picked them, they're going to just fight it out in court. And again, just cost more time and more money. So the solution is to get a will and a standalone guardianship document and name the guardians there. Put your first choice down, and then you could put subsequent choices if something happens to them, or even if you have joint guardians, what happens if they get divorced or something like that. We would walk through all those steps with you. So if you name your sister and she's married and her husband passes away, or your sister passes away, do you really want the husband who's not really your blood relative to raise your kids? Maybe yes, maybe no. That's something you've got to think about and think through, and then name backups as alternatives if the people that you choose initially aren't available. So what about the money, right? If the kids are taken care of, let's talk about the money. Who gets the money, your money that you've worked hard for all your life? Um, when you pass away, if you don't have kids and you want to leave it to your cat, that's fine. We can do that too. But you should have the right to choose where your money goes and who it goes to. So let's talk about the term estate. You hear the term estate planning. What does it mean? People think that they don't have an estate. It sounds really formal and fancy. That's only for wealthy people. But the reality is most of us have, some or all of these assets here, and that would be part of your estate, part of everything. So bank accounts, cars, boats, motorcycles, brokerage accounts, life insurance proceeds, course, real estate, retirement accounts, jewelry, artwork, maybe family heirlooms, intellectual property, business interests, whether you own or a member, all of those together combined is considered your estate. It's basically a summary of everything that you own. And we need to decide, where all this is going to go when we pass away and under what circumstances. Now let's talk about title for a second. Title is important because the asset's going to go to whom it's listed on the title, right? It's depending on how your assets is titled, will depend on how the assets get transferred after you pass away. So there's 3 ways that you can own property at your death. This is in the workbook as well. You can own property individually, jointly, or by contract. So a bank account is not necessarily owned just by you. If you're married or you have a partner, it's usually owned by somebody else with you together. That's considered jointly. An asset like a 401k has a set of instructions like beneficiary designation. So that would be like by contract. So you could have some individually, some jointly, and some that are going to be distributed by basis of the contract. The key is you need to do estate planning even if everything you have is held jointly with your spouse or has a beneficiary designation, because you got to think about what might happen after your spouse passes or who your contingent beneficiaries are going to be. So there are some risks with jointly owned assets. Yes. You may be thinking, okay, I don't need to do estate planning. Everything I own is owned jointly. And if I die, everything is going to go to my spouse or partner. And while it's true that jointly held assets will go to the other owner when you pass away, you have to account for what's going to happen when the second owner passes away, or if you pass away at the same time. So jointly owned assets do avoid probate when the first of you passes, but not when the second passes unless you've prepared correctly. So some assets like life insurance have kind of like a built-in estate plan, right? It gets paid to whoever you've named as the beneficiary when you pass away. And generally these assets don't go through probate, but that's only if the beneficiary is at or over the age of 18 and of course alive when you pass away. If either of those things are not true, the assets are going to end up going through probate. So if they're a minor, all the money that would have passed outside probate is going to be going through probate. So it's just as important that the proceeds might be paid outright. Maybe you don't want your 20-year-old to get your $500,000 life insurance policy. That might be something that you might not want to have happen. So there are no rules in place. If that's okay with you, that's okay with you. But if you want to put some rules and some guidelines and some bumpers, then just having them as a beneficiary is not really going to work. So, now that we've determined you need an estate plan, no matter what kind of assets you have, what are your options? And as we go through these 2 options, you should think about what makes the most sense for you and your family. Now, it's important to understand what comprehensive estate planning is, right? Not just estate planning, but comprehensive estate planning, and why most estate plans just won't work when you might need them to. And I've seen, after doing this for a long time, is that a lot of documents maybe they're poorly drafted, they don't address real life issues that families face, like blended families or children with special needs or estate tax issues. And they're kind of cookie cutter, and they may not address the things that you really care about. The other big problem is that many estate plans are usually just a last will and testament. Oops, sorry about that. So they're usually just a last will and testament, which is not enough, and that's good. but the will really only goes into effect after you pass away. Many people think that having a will bypass probate. That is not correct. Simply gives the court a roadmap on how to proceed through the probate process. So it does not avoid probate, it does not avoid that time and expense. And most of the time, those types of estate plans are not updated frequently enough to keep in pace with the changes of your life. So this is really why it's preferable to work with an attorney. Of course, I wish it's me, but if not, just work with somebody that is knowledgeable and experienced. And then, of course, the last issue is, most people don't want their kids to get their inheritance when they're 18 or at an age where there may be a risk for not using it or spending it properly. So you're going to have two options. Either you're going to do a will-based plan or a trust-based plan. That would be a revocable living trust or living revocable trust. Doesn't matter which one you call it, it's the same thing. This is a decision that you're going to have to make, whether you're married or you're single, if you have kids or you don't have kids, regardless of how much money you have. You kind of get to decide, do you want a will or do you want a trust? And as I mentioned, most of my clients today choose a living revocable trust, but I want you to understand both options. And then this is another question in your workbook, to see which one would be a better fit for you. Now, let's talk about the last will and testament. What does it accomplish? Now, it is certainly better than nothing, right? It's where you're going to name guardians for your kids, beneficiaries for some assets. You can name an executor, which is the person who's in charge of the probate process as you go through it. They're going to gather your assets, notify family members, pay creditors, and do all those things that they have to do. Most of them are going to do it with a lawyer. And, it'll get that done. So that's good, but that's all it will do. It can't give you that other protection that we talked about or that we're going to talk about. And having a will means you're going through probate, and that comes with a lot of downsides that people are not really aware of. So here's some examples of where a will kind of fails. First of all, you're going to go through probate court, and we'll talk about that in a minute. There's no provision for incapacity. Your will is only in effect after you pass away. So if you are alive but incapacitated, it's not really going to help you. If you own assets in another state, you're going to end up going through probate in that state. If it's real estate property that you own in another state, so it's not going to help if you're crossing state lines. There's some property that it doesn't control, right? It doesn't give you that overall protection. And it doesn't help you during your life. It doesn't help you if you're incapacitated, and not for the lives of anybody else that's involved either. So, like I said, where there's a will is a probate. Doesn't avoid probate. It simply gives the court a roadmap on how to proceed. All right. This is at least my truth. Probate court equals bad. Most people who've gone through the probate process with any decent size estate have generally had a negative experience. And you can talk to friends, you can talk to neighbors who have done it, and they'll probably tell you the same thing. Now, I don't think it'll be as bad as Colonel Jessup here, but it is a very difficult and challenging process. So for those of you that are not familiar, kind of what is probate court? This is kind of like the high level overview. The main purpose is to change assets that you own from your name to your loved ones. The court will appoint an executor. They're going to publish notice in the papers so that people are aware and creditors are aware. They have to do an inventory. They have to pay the creditors. They'll distribute assets. Everything goes through the judge, and the court has to give permission for everything. And most people are going to hire a lawyer because there are certain processes and procedures to follow, and they don't want to be held responsible if they get screwed up. But here are the four main downsides to probate. Number one, expensive. It's going to cost, quite a bit of money. We're going to go through these in a little bit more detail. It's time consuming, it's public, and a loss of control. So time, money, publicity, and lack of control. In terms of the cost, right, that money, in Ohio, attorneys, and most people, like I said, will hire an attorney to help them go through probate. they can charge a fee that is equal to a percentage of the gross value of the estate that goes through probate. So if you have your real estate, that's fine. But if you have minor children, which we'll see on the next slide, this can really add up. So if you want to take that average of about 3%, keep that in mind. And this obviously reduces the amount of money that goes to your family and your loved ones. So here's a hypothetical example. Let's say you have a house that's worth about 400,000. You have some rental property worth 100,000. You've got some stocks and bonds. You got a life insurance, but it's payable again after the primary. If you're married, if it goes to your primary, to your spouse, but then it goes, you both pass away at the same time, your kids are named and they're minors. You've got this $1 million policy and money that's going to go through probate. And then you have a small 401k. So let's just pretend it's about 1.81 million. And I think people are surprised by that amount, and they don't realize how quickly some of these assets can really add up. So if you do that, and you take the conservative figure of about 2%, that's about $30,000, $36,000. That's money that's going to an attorney and to the courts and not going to your minor children. That's a lot of money, but if you're okay with that, you're okay with it. It just depends, right? If you've got money to burn and you're okay with that, then that's fine. There's nothing wrong with it. But most people would prefer to save that money and have it go to their children. Now, in terms of time, probate is time consuming. It takes about 12 to 18 months to go through. Even relatively simple estates can take a while, and all those assets are frozen until the probate ends. Now, if your younger children need money, if their guardian needs money for them to do things, they're going to get that, but they have to first go to court. They have to make a petition. They have to possibly have a hearing. It will depend on what it is, and then get the money. So it's obviously a big hassle because the assets are frozen and the judge has to approve those transactions. And probate is also public. Anything that happens in an Ohio court is a matter of public record. So anyone can see who you are, who your family is, what your assets are, and where they're going. And there are some companies that will solicit beneficiaries for, business opportunities and investment opportunities and things like that. And a lot of people are uncomfortable that their life becomes, an entirely open book through the probate process. So here's some examples of where probate fails to protect your money, right? Number one, your kids get their money outright at 18. So if you're like this guy, you're just going to be spending money. Are they really going to have that, for their later on in their lifetime? There's no regard for being financially responsible. I should say financial responsibility. Sorry about that. It doesn't matter if they're good with money or not good with money. That's when they're going to get their inheritance. And it doesn't help kids who have special needs. They could lose their benefits if they receive an outright inheritance without proper planning. So there are some circumstances where a bill-based plan is appropriate. If you have less than $75,000 in Ohio, it's probably going to make sense. You get a simplified process. Going to be a little bit easier, or maybe you only have all adult children and wonderful, happy marriages, and they all get along with each other. In this case, probate avoidance is not really necessary, and a will is probably going to be sufficient, assuming all of these things are basically true, and you're not concerned about long-term asset protection for your children or your grandchildren. So it could work. It just depends on you and your personal family situation. But if if none of those circumstances are true, right, and if a will is not the answer, what is? And the answer would be a revocable living trust, sometimes called a living revocable trust. Like I said, it doesn't really matter. This is what most of my clients choose based on their personal situation. So what is a revocable living trust? It's like a will kind of on steroids, sort of. It's a document that you create that's similar to a will, except that it keeps everything private. You get to name beneficiaries for your assets in the trust. It's completely revocable. So anything you do today as an individual, you can do tomorrow as the trustee of your own trust, right? The manager of your own trust. You are the trustee. You are the manager of that trust. You have total control during your lifetime. When one of you passes away, the survivor is the sole trustee. And when the survivor passes away, you name a successor trustee. So you have complete control over all of your assets. The difference is the trust is the owner, not you as an individual, and therefore it avoids probate court. Okay. Everything you know today is outside your trust. So we go through a process after you create your trust to call trust funding, which is moving your assets out of your individual name and into the name of your trust. This is something that we help you with as part of our process. And then when you both pass away, because the trust is in charge, there is no probate. You don't have any assets when you pass away in your individual name. The trust owns everything, and the successor trustee steps in and they manage the assets or distribute them to your beneficiaries as you've set forth in the trust. I know, right? This is brand new information, but the reality is, this is kind of how it's been done for the past 30 years. That just not enough people know about it. Now, there is a misconception out there, right? Aren't trusts only for rich people? Like, oh, I don't have enough money, or you're watching, movies or TV shows and hear about trust fund babies and things like that. But that is definitely not true. It's not just for wealthy people. So, in terms of getting a better understanding of what a trust is, it's an agreement that spells out the rules you want followed for your assets, which are owned by the trust after you pass away. That's it. So it solves all those problems as a will because it is private and and therefore it does not go through the probate court. So here's an example. Let's say Bob has $100,000 in a bank account. He wants to leave it to his son, but he wants his son not to get it until number one, he's at least 25, and number two, he has graduated college. Well, these are some rules he wants to put in place. The only way to do that is through a trust, through a living revocable trust would be the most common way to get it done because he wants to control how and when his son gets his inheritance. Now, there's three roles in every trust. There's a grantor, which is the person who contributes assets to the trust. There's the trustee, which is the person who manages the trust assets. And then there's the beneficiary, and those are the people who receive the trust assets at some point. Now, here's an example, right? We have Harry and we have Wendy. Harry's the husband, Wendy's the wife. That's all it's for. Now, they set up a living revocable trust. While they're alive, they serve in all three roles. They act as the grantors who created the trust and transferred the title of their assets into the trust. They are also the trustees of the trust. I should really reverse that, right? They're the trustees of the trust. So they have the manager's role and they decide what the trust owns, what it buys, what it sells, whatever they do today as individuals, they can do tomorrow as the trustees of their own trust. And they're the beneficiaries, right? They get to live in their house and spend the money of the accounts and do all those things. So while they're alive, they occupy all three positions. Because it's a living revocable trust, that means they can change any of the terms of the trust or the assets of the trust. Put assets in, take assets out, buy and sell, whatever they want, also change the terms if they feel that that ever becomes necessary. So the magic is how you hold title to the assets, right? That's the secret, okay? If you own them in your individual name, you're going through probate. If a trust owns them and you don't have them in your individual name, you will avoid probate. So a revocable living trust is kind of like a kid's backpack, right? And this is another question in your workbook. When a kid starts school, right, they can pick out any backpack. They have styles and colors and sizes, all these different options. And your trust is the same way. You can set it up so it accomplishes what you want it to accomplish specifically, different goals, different values, whatever it is. The main goal is for your trust to hold all of your assets because then those assets will be distributed according to the terms of the trust. So it's only as good as the assets that it owns. It avoids probate for anything that is inside of the backpack, okay? You set it up first by the contract, and then you transfer your funds to be owned by the trust. And when you pass away, everything held by the trust goes to your family without any probate court involvement at all. So empty backpack is bad, right? Filling up your backpack, right, with your assets into your trust, the backpack being the trust and everything inside being your assets, that is good. You want them to be inside the trust, inside the backpack. So funding your trust just means changing the ownership and retitling the assets so the trust owns them instead of you individually, just like this lady's putting all of her stuff in the backpack. You're going to put all of your stuff into your trust. And this solves all the problems that normally come with a will. You're not going to lose the 2 to 5% in attorney fees going through probate court. Uh, Transferring assets will take a matter of weeks, not years, and it's totally private during life and after death. So a few other benefits of revocable living trust. Number one, they are revocable, so they're easily changed if you need to change them. They are valid in almost every state. I think it's 33 or 35 states have all signed on to the Uniform Trust Code. So if you create one in Ohio and move to one of the other states, it's likely it's going to be valid. Obviously, you should get it reviewed by an attorney, but there's a very high likelihood that you won't really have to change anything. Now, they're not asset protection trusts. Those are a different kind, a different animal altogether, but they are much more difficult to attack even by your creditors, and certainly for your beneficiaries' creditors, your kids' creditors. It's much more protected. No separate tax ID is necessary. It gets taxed under your own Social Security number. It's a pass-through entity from the IRS's perspective. And after you go through the setup process, it's not really difficult to create and maintain. It creates one kind of backpack, one place to put all of your property and all of your assets. Now, what about guardians, right? So you're still going to get a will, a pour over will, with your revocable trust, and you will get a set of standalone guardians. That's where you'll nominate them. Now, people ask, well, wait a second, if everything is going through the trust, well, what do I need a will for? So the answer is, we'll create a trust for you today. We'll help you fund it. But in a few years from now, if you acquire an asset and you totally forgot that you have trust, and you buy that asset in your personal name and then you die, right? That asset's going through probate. So you want to have a will. It's called a pour over will because it tells the probate court, hey, court, if I die with assets in my own individual name, please put them into the trust, pour them into the trust. That's why it's called a pour over will. So you are going to get a will. We'll name the guardians there. We'll name them in standalone documents as well. So here are some things that parents worry about, after they're gone, right? Um, hopefully by now you've kind of decided which one you want. And the next issue is, how do you accomplish this? And one of the things that parents want their trust to accomplish is that the money that they leave their kids isn't spent unwisely or squandered, otherwise lost in some other way. And so there's a few things that they look at. They don't want their kids to lose their money if they get divorced, and they don't want to lose their money if they get involved in a lawsuit through their creditors or anything like that. So here's a couple of examples, right? We got two grown kids, Denise and Sam. And now let's pretend that Harry and Wendy, haven't done anything with their trust to protect the money later on. They just maybe have simple wills, or they have a trust that gives the money outright. And let's pretend they're going to leave their kids $2 million, right? And each kid is going to get $1 million, which is obviously represents a lifetime of hard-earned wealth. So let's pretend that Denise is married to Jason, who, is not a hard worker like our cat here, doesn't do much to support the family. And Denise takes her $1 million and puts it into her joint bank account with Jason. She's now commingled the money. And if they get divorced a few years later, Jason is technically going to be entitled to half of that money, which is probably the last thing that Harry and Wendy really wanted. They worked hard all their lives, and then to see it go to their daughter's ex-husband, probably not. Now let's talk about Sam, right? Let's say he takes his $1 million, puts it into his account, but he's not married, but he's a little accident prone, and he leaves the water running in his apartment, in the bathtub, and he goes out and he floods the apartment below, gets sued, and now loses the entire inheritance in his lawsuit. Again, this is probably the last thing that Harry and Wendy would have wanted after working so hard throughout their lives to build up this wealth and income. So that's why we recommend that you do a children's trust. This is how we ensure that the inheritance isn't lost to the beneficiaries, divorce, lawsuits, and bankruptcy. Think of it like a tube of toothpaste, which is kind of the best analogy I can think of here. And this is another question in the workbook, right? The mistake that they made is by giving their money outright to the kids, either through a will or even through a trust. Once it's out of the tube, right? Once it's out of the tube of toothpaste, it can never get back in. You can give that toothpaste back in. Same thing. Once the money's out of the trust, you can't get it back in. And it could be commingled. It could be lost to creditors. It could be spent unwisely. There's no way to get it back into the, into the toothpaste tube. And this is unfortunately how many trusts are drafted. So we are able to do something different, and we'll go through that in the next couple of slides, is each child will get their own tube of toothpaste, and we'll set rules around how and when they can squeeze out the money, how and when they can receive their inheritance. So this way it stays protected and avoids losing the money to creditors, bankruptcy, lawsuits, and divorce. Okay, there's another little example. So when if you want to put these protection in place, you want to set up a children's trust along with as part of your general revocable living trust. Now, what about estate taxes? Let's kind of cover that real quickly. Estate tax is a tax that's due when someone passes away if they have more than a certain amount of money. Now, Ohio does not have a state level estate tax, so you don't have to worry about that, but there is a federal estate tax. However, there is currently an exemption of up to $12.9 million. And depending on when you watch this video, you should reach out to me or another competent attorney to see if that's still in effect. That number is supposed to change. Right now, it's 12.9 per person, meaning a married couple or jointly, partners that are planning together can pass over $25 million to their loved ones, estate tax-free, if they do set up a proper living revocable trust. You have more than 25 million, that is beyond the scope of this webinar, and I'd encourage you to reach out to the office. Now, the information of the program is over. So the next question is, what do you do next? And I would certainly love the opportunity to work with you and your family. So these are the questions to go through, right? What do you need to do? How do you make it happen? When should you start? And what's the investment to get it done the right way? So first and foremost, you might be wondering, well, can I just make my own trust? There's all kinds of online tools and things like that. And that's good for, maybe arts and crafts, but I wouldn't recommend, tearing out walls and fixing your own electricity. That's the hard way, right? Same thing for estate planning. It's worthwhile to work with a competent attorney who can get your questions answered and give you the peace of mind that you're looking for. So like I said, there are less qualified options available for families that may not know better. We call these bare bones trusts. They are produced by attorneys who are not focused on estate planning, or maybe they're non-attorneys or some of these websites. I would be cautious of them as they may not comply with state law. They may not have important information that you're looking for to protect you and your family, and sometimes they're not funded. That's usually the case. Which means it was set up, but the transfer of the assets was never done. And then you have a worthless paperweight sitting on your desk. When you work with an attorney, like me, you're paying for guidance and counseling about how the documents should be created and drafted, not the documents themselves. That's where the value is. Now, traditionally, if you worked with a lawyer before, maybe you've heard about attorneys who do hourly billing, so they're keeping track of how much time they're spending on your matter, and there are still attorneys that do that. It tends to be much more of a reactive process and transaction-based. You're a number, right? Your matter starts, it ends, and you don't really necessarily have any ongoing guidance on how to avoid legal problems. When you work with us, we do everything on a flat fee basis, right? I really try to flip the traditional model on its head. You're not going to get charged on every little phone call and email. I really don't generally keep track of the time. You might have a lot of questions about your plan during the whole planning process, and you can call and email and text however much you want. It's very proactive. We try not to respond to negative situations. It's about thinking about possibilities in the future and trying to prepare for them. And we really value our relationship with our clients. We want to stay in touch over time because we know that your estate plan, it's not something you do once and never think about again. Your life is going to change, the law is going to change, your family is going to change, and we want your plan to keep up. So this is how our virtual estate planning process works. Number one, you watch the webinar, which you've already done. If this makes sense to you and you feel comfortable with me, you'll schedule a design meeting, which we'll talk about in a minute. After we have the design meeting, we'll prepare your we might have a planning meeting in between, depending on what your availability is. But either way, after your documents are drafted, we'll send them to you with a video explaining everything. And once you are comfortable with your drafts, we'll schedule a signing session. We will have a notary public come to your home to take care of the signing session. So you, again, never have to leave your home to get these done. Now, you get what you pay for in life, as I'm sure you've heard. You want to hear some examples. You want to avoid bargains, right? Your parachute, fire extinguishers, brain surgery, and of course, estate planning. It's like anything else. You're going to get what you pay for, and not planning is going to cost you much more than doing proper planning. So the goal is, to try to save you money, and we want to try to save you at least $25,000. Even if that's all you own is a house worth 400 or 500,000, and you want to spare your kids from possibly losing their inheritance. So the good news, of course, is that our estate planning packages are significantly less than $25,000. So we have three different flat fee plans based on what your personal situation is. We have a will plan, which is as it sounds, it's a will-based plan that, again, won't avoid probate. But if you have those fewer assets, that's where it might make sense. You have a standard trust plan, which we'll talk about in a minute, and then the platinum plan, which is when you have more than $6 million in assets, then we need to start talking about advanced estate tax planning issues to think about. The standard trust plan is where most of my clientele falls in to that bucket. And we'll go over on the next slide what is all included for that investment. You can see there's a difference for individuals and couples, but it is an investment in protecting you and protecting your family. So the trust plan includes a living revocable trust, which we've talked about. It includes the pour-over will, which we mentioned. It includes the children's trust, so we will do both for you together. And then it includes a set of documents to take care of you and your family. You get a financial power of attorney, a healthcare proxy or healthcare power of attorney. You get a HIPAA waiver. You receive a living will, which is an end-of-life document and lets you determine when you want medical treatment withdrawn, so you can pass naturally. It includes the nomination of guardians documents that we've talked about. We will also transfer your primary residence into the trust for you, and then we have a slight small charge if you have additional properties in the state of Ohio. And then we give you 90 days of unlimited guidance on getting the rest of your assets funded into your trust properly. That trust funding portion, this is something that we do, I think, is a little bit different than most other attorneys. We'll give you 90 days of unlimited guidance. We have a schedule of assets. We have check-in calls, check-in emails. We are going to hold your hand and hold you accountable towards getting your trust funded. We provide you with documents in a leather-bound binder. They're tabbed, they're marked, they're organized. We'll have a notary public come to your home for the signing session. We'll provide you with a guide on for the successor trustee, a guide for what happens when someone passes away, a guide for how to transfer assets into your trust in the future, and then, of course, final disposition documents that can indicate whether or not you'd like to be buried or cremated. So it is a comprehensive estate plan. So we've watched the webinar. If this is the right fit for you and you would like to work with us, we would recommend that you then schedule your design meeting to go over everything with us and then move forward through the process. Here is the design meeting agenda if you'd like to work with me and with our firm. First of all, if you're married or in a relationship with a partner, both spouses, both partners must attend by phone or by Zoom. We'll give you an online profile to fill out, so just some advanced paperwork that's going to help us through the process. We'll answer your questions. We'll discuss all your goals. We'll help select the correct package for you. Once it's agreed, we will send you a client engagement email. It'll come electronically. You can review it and sign electronically. You will receive an invoice electronically that you can pay by a secure web portal, and then we'll move forward towards designing your estate plan for your family. So here's the bonus I was talking about at the end. And this is a $250 credit towards your estate plan. This is for either of the two trust packages. It is not for the will package, unfortunately. And this is if you schedule your design meeting within the next 96 hours and it takes place within the next 2 weeks. Obviously, we have limited capacity, can't work with everyone. We try not to work with everyone. We know that we're not the right fit for everybody. So we try to work with the clients who are a good fit for us and we're a good fit for them. So if you select one of those trust packages and you schedule that design meeting, you will receive a $250 credit towards your estate plan. Now, who do we work with, right? People who have watched the whole webinar and they are educated and they want to make an informed decision. You don't have an estate plan, or maybe you need to update your existing plan and you're ready to get started. If you're not ready to get started, that's okay too. But we would ask, maybe schedule your design meeting for a later period of time, or just reach out to us whenever you're ready. If you're a do-it-yourselfer, we're not the right fit. If you've got documents in place and just want a second opinion, we're probably not the best fit. And if you have questions, but you're not ready to move forward, then just reach out to us and we'll get those questions answered for you. We can do a quick 15-minute, follow-up call, but let's not schedule the design meeting if you're not ready. Again, I would encourage you to go ahead and look at our Google reviews, either by Googling the website, Googling the law firm name, or going to the website, jeffblaw.com, and take a look and see what other people's, what their process has been like, how they feel about it. There's probably 50 or more, as I mentioned, reviews there. Now, if you're ready, you can just go to that link. I'm not sure if it's clickable here, but hopefully you can jot it down, and you can go to that website. It's a scheduling site. If you are not able to jot it down or you can't get it, I'll try to have it the link on the side, and then you can click on there and schedule your design meeting. If you're not ready, you can schedule the 15-minute follow-up call, and we can get your questions answered for you. So I thank you so much for your time, for your attention. I hope this was worthwhile. I hope it was educational, and I hope it was informative. If you have any questions about us or the process or the packages or the fees or anything like that, please go ahead and reach out, and we'll be happy to help. So again, thank you so much for your time. I really appreciate it. And if you do have any other questions, please feel free to let us know. And if not, I hope you have a wonderful day.